Ninth Circuit. The appeals court reasoned that because raisins are personal property, their seizure was not a categorical or per se taking. The Supreme Court heard arguments in Horne this morning for the second time in 2 years. The first time around, Justice Kagan asked rhetorically whether the raisin marketing order is a taking or just the world's most outdated law. Did the justices' questions this morning shed any light on what the court's answer will be this time around? We're pleased to provide you with some insights this afternoon from 3 attorneys who authored briefs in Horne and attended the arguments this morning. They're going to give a presentation, each one of them, in the order in which I introduce them, and then we'll be happy to take any questions you might have. If you're an online viewer, it's interactive at WLF.org, and I will direct the question to the correct speaker. Leading off today is Stephen Schwartz, who's an associate in the Washington, D.C. office of the law firm Kirkland and Ellis. His practice has included state and federal commercial matters in the discovery, dispositive motions, trial, and appellate stages of litigation. He previously served as a law clerk to Judge Jerry Smith on the U.S. Court of Appeals for the Fifth Circuit, and he was a co-author of the brief for the petitioner in the Horne versus USDA case. Following Stephen will be Timothy Bishop, who's a partner with the law firm Mayer Brown, based in its Chicago office. Mr. Bishop has briefed over 60 cases in the U.S. Supreme Court and has argued 5. Prior to joining the firm, Mr. Bishop served as a law clerk to Justice William Brennan and also to Judge James Oakes of the Second Circuit. Mr. Bishop is counsel of record on an amicus brief filed by the Center for Constitutional Jurisprudence, also in support of the petitioner in Horne. Finishing off will be our own Richard Samp, who is chief counsel of WLF. Mr. Samp litigates regularly in federal and state courts, has represented WLF on comments and requests for rulemaking is filed with numerous federal agencies, including the U.S. Department of Agriculture and the EPA. He argued successfully on WLF's behalf before the U.S. Supreme Court in an original WLF lawsuit involving the Takings Clause, Phillips versus Washington Legal Foundation. He's also counsel of record in WLF's amicus brief filed also in support of the petitioner in Horne. Stephen, if you could get us started.
Well, thank you very much, Glenn, for that kind introduction, and thanks very much to WLF for inviting me to come and talk about this very interesting and very exciting case. So, as you all know, this is a Takings Clause challenge to Department of Agriculture regulations called the Raisin Marketing Order. Now, the way the raisin market works is that raisin producers who grow the raisins sell their crops to raisin handlers who then manage the sale of those raisins to wholesalers, export them, etc. But under the Raisin Marketing Order, a percentage of a year's raisin crop that's transferred to the handlers is supposed to be held in reserve for the account of, that's the term used in the regulations, for the account of the Raisin Administrative Committee, which is an agent of the Department of Agriculture. The raisins that are held in reserve are called reserve tonnage raisins as opposed to free tonnage raisins. Now, producers of raisins aren't paid for reserve tonnage raisins. They're only paid for the free tonnage of what they transfer to the handlers. And while free tonnage raisins can be sold on the open market through kind of ordinary channels by the handlers, the Raisin Administrative Committee, again, agent of the Department of Agriculture, has total control over the sale of the reserve raisins, and it also gets to keep the money. Now, in theory, that money is supposed to be used kind of for the benefit of producers, but in practice, the vast bulk of it goes to raisin handlers, kind of the middlemen, in the form of fat checks that subsidize exports. So kind of if you think about the Raisin Marketing Order sort of schematically, the net result is that producers lose their raisins and raisin handlers get a big fat check. Everything else just sort of cancels out. Now, when most people think about this program, kind of their first thought is, well, this kind of feels like a taking because you have these raisins that had been owned by producers who grew them, but suddenly are kind of under the complete dispositional control of the government without any compensation. And so what's followed is kind of a long series of increasingly desperate attempts by the agency and by the district court and by the Ninth Circuit and by the Department of Justice to explain why, well, after all, it isn't a real taking. One striking aspect of that history is that you kind of rarely see the same theory twice. You can literally look at kind of from brief to brief over the course of this litigation and say that, say, the government's Ninth Circuit merits briefing, its en banc petition opposition, its Ninth Circuit supplemental briefing after the last time it returned to the Ninth Circuit after the Supreme Court, its opposition to the cert petition, and its Supreme Court merits briefing all raised different theories of why no taking occurred here. And interestingly enough, all of those theories were different from what the Ninth Circuit decided in the decision that's now under review. Now, I've managed to jot together some more or less coherent notes about the argument kind of over the course of the last half hour, and hopefully I can rely on those well enough to kind of give my interpretation of kind of what all happened. Now, one takeaway is that most of what the Ninth Circuit panel said in the decision that's now under review is more or less off the table. The government didn't really have any defense of the Ninth Circuit's notion that categorical takings doctrine applies differently when the takings clause is raised as a defense as opposed to when it's raised in a condemnation proceeding or an inverse condemnation proceeding. So that's not really around anymore. Also, of particular interest to a lot of the amici, including WLF, the government isn't really defending the notion that categorical takings doctrine doesn't apply to personal property. The government wants to keep on saying that personal property is treated differently in the context of a regulatory taking, but the government isn't really willing to stand by the notion that all that's available for personal property is regulatory takings doctrine. Also, the government doesn't really have much of a defense, or didn't express much of a defense and argument for the theory that the panel ultimately relied on, which is that the Nolan-Dolan nexus and rough proportionality test that applies to exactions in the context of land use permitting controls the disposition here. So some of the key areas of questioning that Professor McConnell had during his argument for the petitioners. Justice Sotomayor turned out to be the most active questioner speaking with Professor McConnell. She raised a couple of issues. One, she raised an issue that, well, maybe this marketing order, the raisin marketing order, is really kind of a tax, kind of an in-kind tax maybe on raisins, citing this case called Leonard versus Earl, a 1920s case that the government cited once in its merits briefing, didn't really rely on. Now, Leonard is an interesting case. It has to do with oystermen in Maryland, and the situation there 90 years ago was that the state of Maryland required that oystermen hand over 10% of the shells of the raisins they caught for use in various kinds of conservation programs, basically to kind of seed the ocean floor. And kind of on the face of it, that's a sort of sensible line of questioning. And the first time I looked at that case, I thought, well, that does sound kind of like this case. It turns out, though, and this is what Professor McConnell explained to the court today, that Leonard versus Earl addresses kind of a unique kind of situation, because oysters, as funny as it is to say this, they're wild animals, meaning that meaning that the state has title to them to begin with, and you don't have any property rights in them except what the state decides to give you. And that's obviously completely different from raisins. I mean, you own land, you cultivate the land, you grow the raisins are yours. It's a completely different kind of situation. Second response to that, which is also something that Professor McConnell pointed out, the court has made pretty clear in recent years, for example, in the Kuntz case, and before that in the Brown case having to do with IOLTA funds, that the court really won't recharacterize a taking as a tax in order to change the analysis under the Takings Clause. The possibility that the government could do something similar in the form of a tax might go to the issue of public purpose, but it doesn't go to the question of whether there's a taking, what kind of taking analysis applies, whether there's just compensation, etc. Another issue that Justice Sotomayor raised was the case of Ruckelshaus versus Monsanto, a case where, as a condition of registering a pesticide, companies were required to basically sacrifice some of their trade secret rights and put it all in the public domain. Now, Monsanto is distinguishable on a number of grounds, most importantly on the grounds that the court outlined a few years later in the Nolan case, having to do with land use exactions, where Nolan made clear that Monsanto only applies in the case of a voluntary exchange, that was the term used, a voluntary exchange in return for a government benefit of some sort. And it made clear that the right to just use ordinary articles of commerce in commerce, for example, in the case of Nolan, to build on your land, isn't the kind of government benefit that allows the government to exact some kind of in-kind compensation in return. A couple of issues came up about, for example, from Justice Ginsburg, this was the first line of questioning, about whether the raisin producers are actually better off with the marketing order than they would be otherwise. Now, there are a few reasons that they aren't. One is that to the extent that there are any benefits from the raisin marketing order, they would come from raising the price of raisins and stabilizing the price of raisins. The important thing to keep in mind about that, though, is that the government can do that without taking control or possession or ownership of the raisins at all. All it needs to do is impose a volume restriction on the number of raisins, the quantity of raisins that go into commerce. This, incidentally, is what the government does in the context of a variety of other marketing orders having to do with other agricultural commodities. The raisin marketing order kind of stands apart from that. Another point is that, kind of related to that, is that a lot of the notion of the government benefits that come from the marketing order kind of rest on the assumption that these raisins wouldn't be sold otherwise, that they would just rot, that they'd never be sold. The record is actually pretty clear that that's not the case. The public documents show that in any given year where there's a raisin reserve, the government is able to dispose of all of them, often for something like market value, often for something significantly more than market value. And the government's best kind of response to that, in its brief, it suggests some numbers about how the effects of the order on market price. I don't have enough time now. Maybe during questions I can lay it out a little bit more. But the bottom line is that even under the government's figures, the raisin producers end up behind money-wise by pretty substantial amounts of money. A few other issues, for example, Justice Kagan raised some hypotheticals having to do with other things that the government can demand. For example, demanding documents, demanding information in documents, kind of to test the limits of the sorts of rules that we're advocating as petitioners. Professor McConnell's response was to point out that, and this is quite correct, that the government can always demand information, but kind of the line is drawn where the government demands either kind of a physical object, if that's the significance of the documentation that the government is asking for, or if it's demanding some kind of right, as opposed to simply the information, or where there's some kind of permanent physical, especially where there's some kind of permanent physical thing or permanent physical right that's transferred over to the government. Perhaps most interestingly of all, a number of justices, I think a lot of these questions from Justice Ginsburg, Justice Sotomayor, Justice Breyer, focused on questions of remedy. One of the issues that the government raised in its brief was that in the event there is a taking, the proper remedy for the court is to remand to the district court or to the agency to do kind of a big macro accounting of all of the benefits of the raise and marketing order and kind of credit those against the Hornes and then figure out what kind of fine would be appropriate. Now, we have a number of responses to that. Kind of most importantly is the fact that the regulations, the marketing order doesn't contemplate any kind of accounting. I mean, the regulations contemplate that in the event of a violation of the marketing order, there's a particular kind of fine that gets calculated in a particular kind of way, and that's it. And that fine will rise or fall depending on the constitutionality of the underlying demand that the handlers, in this case the Hornes, give up the raisins. To do anything different would basically be to rewrite the regulations, and the court simply isn't appropriate to do that. And that kind of tallies with general principles of takings law, where generally speaking, when the government demands what would otherwise be an uncompensated taking or imposes a penalty for refusing to accede to what would be an uncompensated taking, the typical remedy, and this goes back more than 100 years, is simply to reverse. If the government wants to get what it wants through some other means, it can kind of start from the beginning and do a condemnation, which of course wouldn't really be an option here, the way the regulations work. And so there's really no point and no authority to go back for an accounting. How much time? Do you have another minute? 3 minutes? Okay, then I'll say just a little bit about the Solicitor General's argument. The Solicitor General, interestingly enough, conceded that the Raise and Administrative Committee takes title to reserve tonnage raisins. As far as we're concerned, this was the first point that Professor McConnell raised in his rebuttal. That more or less resolves the case, because if the Raise and Administrative Committee is taking title to the things, then it's a taking, and the only remaining question is whether there's just compensation, which there clearly isn't, and in any case, authority is quite good that when there's a penalty for refusing to submit to an unconstitutional taking, it rises or falls with the taking itself. That basically resolves the case. The government didn't have any good answer to hypotheticals that a number of the justices proposed, suggesting, for example, it was Justice Alito who raised this first, suggesting that if the raise and marketing order can stand, then the government can simply demand that a cell phone manufacturer has to turn over every fifth cell phone. And the Solicitor General simply didn't have a response to that in my understanding of how the argument went, which is kind of an astonishing proposition. A few of the justices were interested in the Solicitor General's view of the consequences of the program, whether a ruling in favor of petitioners here would kind of upend large amounts of administrative law. We consider it a good sign that that's something that's on the justices' mind. But at any rate, the important thing to keep in mind is that there are very few of these programs out there. Very few of them are actually in effect. And again, any benefits that come from the program you could get by other means that would create potentially other concerns under the Constitution, regulatory takings, whatever, but that wouldn't create kind of categorical takings problems under the Fifth Amendment, like what we're talking about here. So kind of the bottom line is that the concerns that that the Supreme Court raised were ones that were largely discussed in the briefing, not particularly surprising, ones that, in my view, Professor McConnell responded to in fairly persuasive ways, and that ultimately the Solicitor General got the worst of it, got some of the harshest treatment, and didn't have a lot of answers to kind of the most critical questions about the constitutionality of the program. Thanks very much, Glenn.
Thanks, Stephen. It's great to get that from someone who's so familiar with the background of the case. Jeremy Jacobs in Greenwire the other day, his headline was that the Supreme Court is to face a gnarly takings case, which it's a phrase I really liked. It's a word that I think at 10 o'clock this morning you might have thought that, yes, potentially there are some gnarly issues in here. One is the sort of the overhanging producer-handler issue. The Hornes here set up a new scheme in which of marketing in which they would both the producers and the handlers, and that sort of created some issues about who's really got the claim here. And that was one of the focuses of the last time that this case came up to the Supreme Court. But the SG tried to make something of that again in its brief. Another jurisdictional issue hanging out there related to the producer-handler problem is there really jurisdiction here, or is this only a sort of claim that can only be brought in the Court of Claims under the Tucker Act? And the government had argued in its brief again that the claims of the Hornes are really producer claims that can only be brought under the Tucker Act and really don't belong in this court. And then there's the compensation issue. And at the end of its brief, the government says, well, compensation here is a tricky issue when you've got to weigh the benefits and the burdens of this regulatory scheme to see if there is anything to compensate or if compensation has already been paid. They actually claim in the last page of their brief that if you weigh these benefits and burdens, it's likely that the Hornes ended up with a net gain as a result of the scheme. So there are at least those three difficult issues that could have messed up, I think, the case, and people could have focused on those to the exclusion of the core issues in the case. And I think one of the refreshing things about the argument today is that really none of those got in the way of what I think will be a clean decision, albeit a narrow one, focused on what are really the critical points in the case. And, the first of those, and the one that we devoted our amicus brief to, is the protection of personal property. I mean, if you're thinking about the dangers in this case going into it, the foremost among those would be, is there going to be some lesser protection of personal property than of real property? And the reason that that's a real issue in the case is because the Ninth Circuit decided it that way. The Ninth Circuit basically said that personal property is less important than real property and therefore can be regulated away more easily without running into a takings analysis. Now, that, of course, is a very scary proposition, and it's the reason why many of the amicus briefs filed in support of the Hornes here focus on establishing in the court's precedent and the historical antecedents that personal property is just as fully protected under the just compensation clause as real property. And our brief traced back the protection of property rights to Magna Carta and established that the main concern in the Magna Carta was in fact personal property rather than real property, because real property was actually subject to fewer protections if unimproved real property was not considered to have been reduced to ownership, and so could be taken from the crown. The principal problem that the barons and the people saw when they went to King John was that the king's 70 castles were demanding to be provisioned, and provisioned from the fields in the surrounding areas. They were demanding that the castles be kept warm by taking the timber that was being grown by the villagers. And they were transporting the provisions and the timber to the castles by taking people's oxen and carts to do that with. all of it personal property. Later, when the Magna Carta, which by the way is ensconced both on the grand bronze doors of the Supreme Court and in the friezes, when the Magna Carta became one of the foundations for the U.S. Constitution, it was clear that personal property at that time was also of great importance. In the colonial period, as the principles of the Magna Carta began to be embodied in the law this side of the pond, the concern again was the victualling of troops, and agricultural products in particular were most at risk of being seized, and payment for those products was at the forefront of the minds of those seeking to protect property rights. Now, the government, as it turns out, is not quite brave enough to join with the Ninth Circuit and say that personal property deserves little or no protection under the Takings Clause. Their approach was more subtle, more insidious, but just as dangerous. Here's what I think is the key sentence in their brief. Unlike real property or unique personal property, reserve raisins are a fungible commodity valuable to producers only insofar as they generate sales revenue. The right to possess that sort of personal property is not an essential property interest. That is a truly extraordinary statement, in my view. I mean, economically, it makes no sense at all. I mean, it distinguishes between personal property that is put out into the marketplace and unique personal property. They don't describe what that is, but I don't think there is any such thing as unique personal property. I have a very nice house. My family and I like it very much. We like the antiques and the paintings and so on that we have. If someone offered me the right amount of money for this, I would certainly sell all of it. It's a false distinction in a market economy to say that, well, some things you care about more, some you and will protect those, and some you're just going to sell, so we won't offer those any protection. At the argument, I really didn't hear Deputy Solicitor General Needler defending that. Perhaps it sunk in by the time that 5 or 6 of the justices had hammered him with not too friendly questions that was not going to fly. But it's clearly in their brief, and I think it ought to be a great concern and something we ought to be watching for as DOJ develops arguments in other cases in the future. What the government, I think, has fallen back on is the still very dangerous proposition that personal property, once it is sucked into a government regulatory scheme, loses the full protection of the Takings Clause. That in order for the protections to apply, the government has to cut through all of the strands that go into rights that go into property ownership. That if, in the context of a big regulatory scheme like the raisin scheme, the government says, well, we're going to take possession away from you, but you'll have some sort of constructive trust right to the proceeds if there are any left at the end of this process, that in that sort of situation, if the government can regulate, then the government can take, including physically take, and that should not be treated as a per se taking. That, too, is very dangerous. It's very dangerous for a reason that Chief Justice Roberts pointed out very clearly in questions to the government today, which is, well, government, you can always come up with some explanation of a regulatory scheme and why it is good for people. And the cell phone example that's already been mentioned was a brilliant example. We will, the government would say, improve the lot of cell phone manufacturers of the providers of the networks, the cell phone networks, and the populace as a whole if everyone has a cell phone. There'll be more demand for the service, and everyone will be able to have a cell phone and conduct business and personal life. Everyone will be better off. And there's very little that you can't say that about. The government can always come up with some excuse for why a regulatory scheme will make everyone's life better, including the lot of the people whose property they are taking. And so the Chief Justice's example was, we'll set up a scheme. Every fifth phone, you give us one, and we will give it to someone who doesn't have a phone, and that way you'll have more customers, and everyone will be better off. There is no corner of American commerce that could not be regulated under that sort of reasoning, and property simply taken away to improve the market. So I don't think that is going to go anywhere. And that's, I think, is one of the two key takeaways from this morning, that I didn't hear, I think, any support among the 9 justices for the proposition that the raisins, because they are part of a larger regulatory scheme, are not property in the sense that's fully protected by the takings clause. And then the second point, I think, is to the tests. I don't think any damage has been done to the sorts of tests that we see applied in takings cases today. That was a danger. One thing I was worried about was that there might be a push for some sort of sui generis, some new standard for analyzing takings under these sorts of regulatory schemes. And I didn't hear any of that. And the last thing we need is another takings test. As anyone who works in this field knows, there are too many of them already applied to particular circumstances. So we don't need any more. What I heard this morning was that these raisins are property fully protected by the takings clause. If you physically take them away and take title to them, that is a per se taking, which is the Loretto rule, a simple application of the Loretto rule. It doesn't matter how small the taking is. It doesn't matter if this were 10% of the crop, 5% of the crop, or 1% of the crop. What's important is that it is physically taken away, that the right of possession, which is one of the key strands of the property right, there's been a deprivation of that key strand of the property right. End of story. Per se taking. The more difficult question, I think, in a case like this will be, well, what's the compensation? One answer to that is the one that we've heard that Mr. McConnell gave this morning, which is that this particular scheme doesn't provide for a compensation mechanism. The government's argument is, well, you don't have to look for a specific mechanism built into the regulatory scheme. You can just consider the benefits and the burdens, and there is we heard different factual takes this morning on what that would mean. Justice Sotomayor sort of jumped on the government's argument that that the producers are better off because the prices for the non-reserve, for the free part of the crop, will be maintained. That when you add up all these benefits and burdens, the producers and the handlers are better off. We heard some of that from Justice Breyer. Now, I suspect that the court will avoid this issue. I don't know the record as well as counsel for the petitioners here, but I suspect once they start digging into this, it's a lot easier for this court, which is in any event inclined to proceed incrementally rather than in big steps, to say that we will remand to consider how compensation ought to be dealt with here. So who knows? This may be back up a third time, sometime in the future. But and we may see some concurrences here explicating how individual justices think the compensation inquiry should proceed. But I would not be surprised to see on the core point of is this a taking? Are the raisins protected by the takings clause? Does the Loretto per se test apply? I would not be surprised to see even a 9-0 ruling on that. Justice Kagan and Justice Breyer both said that they agreed with the Chief Justice's basic approach when he described this as a physical seizure that triggered the Loretto analysis. Do I have one more minute? Or, so I mean, just to get to the tests here, we heard the government rely. We've heard they relied on Monsanto. They also relied on Yee, and Yee is a troubling case. This is the California rent control, one of the California rent control cases, and in Yee, the court did seem to rely on the regulatory scheme that pre-existed the renting out of the property as a reason for not finding a taking in that case. The fact is that in the sorts of rent control cases, rent control ordinance involved in Yee, you are stuck with your tenant, and you are stuck with your tenant paying below market rates, and so your tenant is not going anywhere. The tenant is physically on your property. Some of the other cases like Dolan and Nolan, Dolan arising out of the zoning context, and we all know that zoning has had a sort of whole different set of rules applied to it. But in Dolan, you're asked to give up something in exchange for the right to develop your property in the way that you want to. And what you're asked to give up may often include, as it did in Dolan, some physical imposition on the property. There, I think it was a bike path, if I remember right. In other cases, it may be an easement of passage. I think that one thing that has gone wrong in the takings area is illustrated by Dolan and Nolan and Yee, and that is that the court has drawn the line around physical takings too tightly. Essentially what we have now is eminent domain, physical taking, no doubt, per se, the argument's only about value. If you have a regulatory taking that is the equivalent of a physical taking in the sense that it deprives the property of all economically viable use, then it's treated as a per se taking under Lucas. A very rare instance that there's no economically viable use left. Now I think we're going to get personal property seized in order to be sold, and maybe you'll get something back, maybe you won't. I think that's going to be held to be a physical taking to which a per se analysis applies. But outside that, you've got these instances where there clearly is a physical imposition, the loss of a key element in the right of private property, the right to exclude. You cannot exclude someone from walking across your property. If you cannot tell the government, no, you can't build a bike path and let people ride across my property, you have physically given up physical control over a substantial interest. It seems to me that the court, now that we're sort of on firm ground on the core of the physical takings doctrine, needs to start thinking about what's really different in these other areas that have been labeled regulatory, I think, far too easily. All right, thank you.
I wholeheartedly agree with both Steve and Tim that things went very well for the Hornes in court today, and whether it is a 9-0 decision or a somewhat divided court, there is no doubt from the way the arguments went that the court is going to uphold the rights of the property owners, the owners of the raisins in this particular case. One of the difficulties of the case is that it's not as widely applicable as the typical takings case, because this is a case in which the federal government is trying to impose a fine on someone who failed to knuckle under to a government regulatory program, as opposed to somebody who is in court trying to seek compensation from the government. And as a result, that makes the Hornes perhaps a much more sympathetic group of clients than you will see in other cases, so that while I see this case as a victory, it's not necessarily going to be an overwhelming victory for the cause of property rights. I just want to comment generally, though, I think on what I see some of the trends in the Supreme Court in this area of Fifth Amendment taking law. I look upon the 1980s in particular, and into the 1990s, as kind of the golden age of Fifth Amendment property rights. There were some very good decisions that were issued in that time period that overturned some older decisions and gave much broader rights to private property. Certainly, we've been talking about the Loretto case, which kind of invented the per se takings rule that says when you have a physical invasion of property or a seizing of property by the government, is always compensable. No sort of balancing is going to be required. You had the Lucas decision in which the court said that even if you don't physically take the property, but if it's real property and you deprive it of all value, that is a per se taking. And then perhaps I disagree with a little bit with Tim in that I look upon the Nolan and Dolan cases as both very good decisions, because they impose very strict limitations on the right of the government when approving development of private property, that the government may not impose overly harsh conditions on the development rights. You only can do it to the extent that the development is going to impose costs on the society as a whole. I look upon the first decade of this century as kind of a bleak period in property rights at the Supreme Court. Certainly I personally feel the sting of the loss of the Brown case, in which the court ruled 5-4 that the seizing of interest out of bank accounts by the government, out of government interest on lawyer trust accounts, was not a compensable taking. And perhaps the worst decision from that era was the one involving Lake Tahoe, where essentially property was deprived of all value, but what the Supreme Court said was, well, we've only deprived it of all value for a decade or two and maybe a few more decades, but that's not permanent, so it's not compensable. And so I am encouraged by cases like the Horne case and a couple of other recent cases that have come before the Supreme Court that perhaps a corner has been turned. I think I look upon the source of the problems in the early part of the century. I attribute them to Justice O'Connor, who had been a strong advocate of the Takings Clause, and she turned away from it a little bit. The replacement of Justice O'Connor by Justice Alito, I think, has made a real difference in the area, so that there was a very good decision a couple of years ago in a case called Arkansas Game and Fish Commission, I think was the name, and it talked about government-induced flooding of private property. And the government said, well, we only flood it a couple of times a year, so that's not a real physical invasion of a property. And the court said no, that is a compensable taking. And another excellent decision written by Justice Alito several years ago that was referenced earlier, it's the Kuntz decision, in which the court put real restrictions on the right of the government to require payoffs from developers in return for the right to develop their property. So the real problem in this case, of course, was the Ninth Circuit's decision, where the Ninth Circuit had said that we don't really like the per se takings rule. We're not going to apply it at all to takings of personal property just to real property, and I think that is probably more than anything else what induced the Supreme Court originally to take the case. And as Steve and Tim mentioned, the government has totally backed away from that position, so that even though there were a slew of excellent briefs that were written on that point, they ended up perhaps not necessarily making all that much difference, including the brief that we filed, we mentioned that argument because it just simply is not one that the court was taking seriously. It's very clearly not going to distinguish between personal property and real property when it comes to application of the per se rule. And what the government was really reduced to arguing here was essentially a no harm, no foul argument. They were saying, okay, it's well established that we have the right to tell farmers that they can't plant any more wheat than we want them to plant, that we have the absolute right to control what gets marketed commercially in the agricultural area, and that applies to a lot of products. They could probably ban cigarettes or alcohol or any number of products that they don't want to be marketed. And so the government says, well, if we can do that, what's the harm of taking a few tons of raisins since you couldn't sell them anyway, because we would have the right to stop them from being marketed. And as Steve mentioned, there are serious factual questions about whether several tons of raisins sitting in your silo would not have any value. It probably would have value over the long term. However, I think that the court made it very clear today that it's rejecting that no harm, no foul argument, that it wants to maintain that very clear line between, on the one hand, regulating commercial activity, even if it means that certain personal property can't be sold at all, versus actually physically taking it. I think that the point that Justice Scalia made repeatedly was one that the Washington Legal Foundation made in our brief, which is the unconstitutional conditions doctrine prevents the government from saying that we'll allow you to engage in commercial activities if you want, but as a condition for engaging in that activities, we're going to force you to relinquish some of your constitutional rights. So, for example, the government cannot tell people that you have no First Amendment rights to speak out in return for, say, getting a government job. And by the same token, the unconstitutional conditions doctrine does not allow the government to say, okay, you can market some raisins if you want, but in return you have to forfeit your Fifth Amendment rights and turn over a lot of your property to us. The Kuntz decision that I mentioned before was actually very much based on the unconstitutional conditions doctrine. Justice Alito wrote an excellent decision in that case, and as I said, I think Justice Scalia picked up on that theme in today's argument. Going forward, I'm still worried that the court is maintaining a distinction between real property and personal property. As I mentioned, in the Lucas case, the Supreme Court said that a regulation of real property that deprives it of all value is a per se taking. But they had to distinguish some older cases that were out there when they did so. In particular, there was a decision, I think by the name of Allard, involving eagle feathers, where the government said, okay, we're not going to confiscate your eagle feathers. You can maintain them in your house all you want, but if you try to sell them, that's illegal. So maybe they've been deprived of all value, but because it's personal property and not real property, that doesn't make any difference. You can look at them all you want, even though they're now valueless. And that distinction remains on the books. And so long as that distinction is out there, I think it is going to be a difficulty in maintaining property rights cases of this sort. That if the government can say you can't sell your personal property at all, it really does deprive it of all value, and I'm not sure why we maintain that distinction that was first identified in the Lucas case. So I'm hoping that is something that the court can look at in the future. I did want to say I thought the best line in today's oral argument, and got a very good laugh when Judge McConnell was arguing on behalf of the Hornes. He was distinguishing the Leonard case that Steve mentioned, and it was the case involving whether or not the state of Maryland had the right to restrict the marketing of oysters. And what Mr. McConnell said was, well, it is true that raisins can dance, but nonetheless they're not wild animals. And I thought he did an excellent job of distinguishing that feature, because it really does make a difference in terms of what is private property to begin with. I think everybody agrees that property only exists by virtue of the common law and what it is that we agree to protect as property. And if oysters are things that are out in the wild and they don't belong to you, just because you're the one who found them in the seabed doesn't give you the right to take it unless the government allows you to take it. That is a real distinction from, say, raisins, where you were the one who grew them on your own property, and therefore the government doesn't necessarily have a right to take it away from you. And with that, I think I'll leave some time for questions. Thank you.
Thank you, Rich. Stephen, did you want to comment on anything that either Rich or Tim said in the course of their presentations before we do questions?
No, I don't think so. I will leave it to the questions from the viewers.
Isn't it true, Rich, that the dancing raisin ads that were being referred to there were a product of another government program that promoted raisins generically? I think that's actually where they came from.
Yes, and part of the problem is that some people who were raisin producers liked it and others did not, but nonetheless they were all required to pay for it. And so the whole idea of whether people can be forced to pay for ads and promotion that they don't like raises separate First Amendment issues, and there have been a series of cases in front of the Supreme Court about that. And Justice Scalia brought that point up today. I think it was Justice Scalia, where he said that, hey, you better not try to argue here that the group that is regulating raisins is not the federal government, because we ruled in favor of the federal government on these First Amendment cases only because you insisted that it really was the federal government that was doing this, so you can't back away from the fact that it is now the federal government that is seizing raisins.
And was the government trying to make that argument at all in its brief, or any of the iterations of the briefs that they filed that Stephen had said that they changed their rationale many times along the way?
I'm not sure I followed the question.
Was there any point at which the government was trying to argue that it wasn't actually a government program?
No. I mean, it's very difficult to kind of argue that the Raisin Administrative Committee isn't a government agent. I mean, it's created by the Department of Agriculture. It's, Department of Agriculture regulations define its membership, its internal procedures, its powers. It's an agent of the Department of Agriculture.
So how much, I know Tim talked a little bit about the Hornes being a sympathetic plaintiff in this situation because they were trying to defend against fines being levied against them. But how much do you think the larger sort of atmospherics of the case had an impact on the justices here, that the Hornes were smaller producers, that they weren't a raisin conglomerate, that there was gigantic, and certainly there was much more of a significant impact on their ability to continue to produce raisins if the government is taking 47% of their crop one year? How much do you think that's going to factor into what the court does here?
You know, the atmospherics of the case sort of cut both ways in some respects. I mean, on the one hand, there are people who really sympathize with the Hornes because they're kind of small raisin producers. On the other hand, there are people whose instinct is to say, oh, the Hornes are free riders and they're violating the program and trying to get the benefits of everybody else's compliance with the program. I think Justice Breyer kind of fronted that view. My personal view is the fact that these people have undertaken a challenge to this program under these circumstances is kind of miraculous. It's something to be really proud of. there's really no way to get a takings clause challenge to the Raisin Reserve without somebody like the Hornes. You can't have it done by individual producers in the Court of Claims because those are really expensive and very uncertain, and it's just not economically possible. And for everybody else, like the handlers that the order applies to, in order for them to do a challenge, they have to do what the Hornes did, submit themselves to these enormous fines, these enormous penalties, risk financial ruin, and kind of be willing to take that risk. Kind of on balance, compared with that, the fact that they happen to get the benefit is simply one of the consequences of a common law adjudication, where, you know, everybody is a free rider to some extent if they challenge an unconstitutional coercion. But one of the ways we get unconstitutional coercion off the books is by giving people the benefit if they win.
Tim, Rich, any thought on that?
Well, you know, Justice Breyer was repeatedly talked about the free rider problem here, so I'm sure Marvin Horne was unhappy to hear himself described that way, because if there's one thing that seems to me that litigating a case like this for a decade through the courts shows is that you're working on the basis of principle and not as someone who just wants to take advantage of the larger program. So I think as someone not as close to the case as Steve's reading the briefs, you get a very sympathetic view of the Hornes, and it reminds me of Mrs. Dolan, who I think when she was sitting in the front row, I think I remember Justice O'Connell leaning over and pointing her out and talking about what the government had done to this poor woman. So it does make a difference, I think, in these cases.
Mark Chenoweth, our general counsel, has a question.
Well, I have a couple questions. Were the Hornes in court today? Do you know?
They were there.
They were there. Okay. You mentioned a couple times that no one seemed to be defending the Ninth Circuit's decision in the case, and often when no one is willing to defend the court's decision below, someone's appointed to represent the decision below. Any thoughts as to why that didn't happen in this case?
I think it's pretty clear that even though the government didn't defend the Ninth Circuit's rationale, it was quite willing to defend the result. It was arguing very strenuously that the Hornes were properly fined, and given that, the court, I think, was quite willing to have the Solicitor General be the one to defend the position.
And then, Tim, you were talking a little bit about the resolution, or if this gets kicked back, how they're going to decide the compensation issue. Is there any question that the $700,000 fine goes away? I assume that regardless of whatever else happens, that sort of Damocles would get removed.
Well, it's a little hard. I mean, the government devotes so little attention to this in its brief that it's hard to, and perhaps they've done more in the lower court briefs, and Steve could help us on that, but they do have the sense that you have to look at the benefits and the burdens, that the Hornes got more money than they would have done for their free part of their crop, and that I think they're saying has to be set aside against what otherwise would be a claim to not pay this $700,000. So it's not clear to me that the government thinks that fine ought to go away. But as petitioners have argued, the scheme is not set up to balance burdens and benefits. It's you don't turn over the crop, you pay the fine. So I think that from our side of the fence, the fine should be gone.
I suspect that there won't be any remand. I suspect that perhaps Justice Breyer and one or two of the others may argue that there should be, and that perhaps the government could win the case at least in part, if on remand it could be shown that there was some benefit that the Hornes obtained. But I suspect that there were at least 5 votes on the court to say flat out this was a taking. There was no effort by the government to provide any reasonable compensation for that. Therefore, the entire fine is overturned, case reversed, end of the case.
If you'd like me to clarify on
Sure.
what I think would happen to the fine. Well, I think on the government's view, the fine wouldn't go away. I think on the government's view, there'd be a remand, and there'd be maybe a little bit of a credit against the fine for whatever the value of the reserve tonnage raisins might have been. But I think the government then wants to count toward the fine the benefits, the supposed benefits that the Hornes got from selling their free tonnage raisins, like all of their raisins, at a price that was supposedly increased by the marketing order. So I think on the government's calculation, there would still be a fine, probably a very hefty one, maybe even greater one than was imposed to begin with. The problem is, again, that we think the facts wouldn't support it. Two, we don't think there's any authority, either in the regulations or in the case law, for that kind of accounting.
We do have time for a few more questions. If anybody has them, again, it's interactive@wlf.org. Tim, could you elaborate a little bit more on the importance of having clear tests in certain situations here and not expanding to more tests? And one of the things that was discussed in one of the briefs was the concerns that exist if you go towards a regulatory takings type analysis for personal property seizures and how that might create gamesmanship opportunities for regulators. Can you elaborate a little bit on that?
Well, it's still true, I think, that at the general Penn Central balancing test very, very rarely results in any finding of a compensable taking. And if you have a well-advised regulator papering the imposition, it really should be the rarest of cases in which there's Penn Central comes out the right way for the property owner, because the test can be manipulated by the way that you describe the government interests are involved, because the government interests go into a balancing against the nature of the property right that's being taken, and if you pump up the government interests enough, then you'll outweigh the property right. In the middle, once you get out of Penn Central, you get to more teeth in Nolan-Dolan, where you're looking for a substantial nexus between the government imposition and what's going on with the land. So if you're asking to build a big building, it's going to bring in a lot of people, then there may be a nexus to providing, a bike path or more pedestrian access or parking, and the government may be able to require that, and it has to be proportional. So if someone is building a single-family home, you can't require that they devote half of their property to a commercial parking structure for the neighborhood. I agree, it's better, it's certainly better than Penn Central. I'm not sure that I see the same sort of rigor in the application of this. And if you've got, again, if it's manipulable by the regulators who are describing the balancing, the nexus, and with the burden and what imposition on the neighborhood or government interests is being weighed in the balance. So I'm not quite so sanguine about that. The best test, obviously, is a per se test. You don't have to ask anything other than if it's taken, then what's the compensation? We get that in these very limited circumstances. Lucas is definitely not a solution, even in the land context, because I suspect that most courts faced with a Lucas type situation, and with the evidence in Lucas that he could put up a tent or have a barbecue and invite his friends over on the property, would find that that was enough for it not to be a complete wipeout. So, my view is what we need is a more realistic assessment of what is a per se taking. In the land context, for example, if you are regulated out of the use of 1 acre of your wetland out of a 100-acre parcel, in my mind that ought to be a per se taking of the 1 acre, or we shouldn't be involved in these inquiries as to, well, you've got value left in the other 99%, and so we do a balancing and you don't get any compensation. The fact is that you have a physical taking, Lucas-type taking of that 1 acre of wetland in which you cannot do anything productive. The same in Ye. If you have to let people live in perpetuity at sub-market rents in your home, you really have had a physical occupation in the most real sense. And so I'd like to see the court get more realistic about when there is a physical occupation, and to recognize that when you lose the right to exclude from your property, that is a physical occupation.
I certainly agree with Tim that the Penn Central balancing test is a worthless test. I thought it was not too surprising that the Hornes in this particular case simply said, we're not pressing a Penn Central claim. If we don't win our per se claim, we lose the case. And some people, I think, said, oh, why did they make that major concession? And the obvious answer is because the Penn Central test is a worthless test that a property owner is always going to lose. And so that if we're going to continue to have any sort of balancing test at all, it has to be one with clearer rules that is not so easily manipulable by the government.
Stephen, I have to ask, when the back and forth was going on between Judge McConnell and Sotomayor about trying to construe this as a tax in order to avoid the Constitution, was Justice Scalia tempted to ask a question about whether that approach might apply in other situations where taxes are being invoked to avoid other constitutional issues, as happened several years ago in a certain case involving the Affordable Care Act?
I don't recall that kind of question from him this time. I don't think it's in my notes. That doesn't mean it didn't take place. He did have a good zinger about how what the Constitution requires is compensation, not just some kind of conceptual nexus between the taking and some kind of purpose. But it was mostly Professor McConnell who raised the point that you just don't recharacterize takings as taxes.
Okay. Well, I want to thank you for joining us today, gentlemen. For anybody who might have joined us late or have anybody who they know might want to watch this, it will be available as an on-demand video file a little bit later today on our website and also on our YouTube channel. Again, thank you for joining us today.
Thank you.
Thank you.